Hello, everyone. Welcome to another episode of Bitcoin Law Review, the show that's now coming to you a couple of times a month, which is a huge improvement. And we have several stories for today, but one of them is going to certainly dominate, and you guys know exactly which one it is. That is the SEC case against Reggie Middleton. We may or may not start with that. It really depends on how much time our panelists can give us. And we have a packed panel here. Hopefully a few more can join, like Drew and Sasha and Adela and a few more. So let's, I mean, everyone's been on the show before. I don't want to do too much of an introduction. I want to jump literally right into the topics. I'll let someone yell it out first. Do we want to cover the Bitfinex situation, or do we want to jump right into Veritaseum?
Go Veritaseum first. It's the easiest one.
I think that's the most interesting and most complicated one. But sure, let's jump right into that one. So, as a quick background on that, so whenever you guys, we'll do the intros as you talk about, I guess, your views on the case. SEC obtains a freeze of 8 million in assets in alleged fraudulent token offering and manipulation scheme. I find it to be a little bit of a weird. It's like the SEC statement was literally trolling Reggie when they called him a self-described financial guru out of Brooklyn. Like, I thought that was a little too much for an official statement from the SEC. And basically,
where's the lie though? Like, are they wrong? I guess. But before we get in, does anyone on this panel actually know? I remember in like 2015 looking at this and being like, who is this guy? He had like some B-roll of himself, like with some really cool music in the background, appearing on Max Kaiser's show and like doing all kinds of other stuff. And people, RT presenters calling him a financial badass and things like that. But I have no idea where this guy's actually come from.
Well, that's pretty much it, right? Like, I remember watching Reggie on RT. I mean, probably after I've heard of Bitcoin, but certainly before I got involved in Bitcoin. And I got involved in Bitcoin before Reggie did. I met him in New York a bunch of times. It was actually cool to meet Reggie when he walked into New York Bitcoin Center. I'm like, oh shit, that's Reggie Middleton. I remember him wearing his Google glasses back then because that was the cool thing to do before they kind of went off service. So I actually like Reggie Middleton, and everything was going great until he decided to create the Veritaseum token. I did an interview with him 2 years ago after the white paper came out and stuff. And I analyzed the shit out of this token. I criticized it heavily. He answered, my questions on the YouTube channel, most of them. And I knew this was going to be a huge problem, and he was going to get in SEC's hot water. And so did some of the comments from 2 years ago in the YouTube channel. So I'm actually not surprised by this, but this case is a little bit complicated. And I'm going to go over to Silver first because of something you said right before we went live, in that you really didn't expect this to be the one that the SEC is going after first.
So the SEC usually takes, low-hanging fruit and that's what they've done so far in the crypto space. So I'm a little confused here because Reggie has, even just according to this press release, they froze $8 million. There was money there. He hasn't spent it all. He's been working with the SEC for the last 2 years, telling them everything they wanted to know. It's just, it was surprising to me. It's a little disappointing to me because I think there were better cases to come out of the gate with. I think we're going to see a lot more enforcement action start. I think this is the tip of the iceberg. But at the end of the day, this isn't one that screamed fraud. For the mere fact, the money's still there.
We
shouldn't undervalue that.
Yeah, no, I'm going to comment real quick. This one did not scream fraud to me either. I mean, I like Reggie as a person. I didn't think he was, it was a straight up fraudulent SEO where you raise a bunch of money, buy Lambos, and never even try to build the product. He actually believed in his product. I just felt that the product that he was building fundamentally did not require, if it did require a utility token, it should have been like one of the ones that got the SEC's letter of, what do you call that letter again?
Wells
no
letter.
Action, the no action letter, right? So if his product did require a token, it should have been one of those a no action letter tokens, but that also means he wouldn't have been able to sell it as an ICO that would fluctuate in price. I don't know if Jason can comment on this, but if Jason can comment on this, it would be great to hear from him.
Sure, I can comment on a few things. Sorry about the noise in the background. We're having the back to school dinner tonight with kids. So, you know, full disclosure, I've represented Reggie in the past. I consult his litigation team now. So there's some things I can talk about, obviously the things that are public record, and there's some things that I can't. One of the things that I found interesting in the SEC's allegations, and one of the things that you just touched on, Tone, was that the SEC weighed heavily on the fact that Reggie claimed that he had products and services, and then they state forcefully that he didn't. And to me, that's just not true. Reggie was originally running, and I think you guys remember this, UltraCoin, and UltraCoin was long before Veritaseum, and UltraCoin was an experiment and software package that he was doing on Counterparty. And so,
Jason, just to be clear, UltraCoin didn't actually have a coin; it was just called UltraCoin.
Yeah. So no, he was developing the software on Counterparty to basically do what he was doing.
Right. I try to be clear for my audience that don't remember.
Yeah. Is Reggie's attempt to take his existing services, his bespoke research, and basically start using that UltraCoin, if you will, as payment services for existing stuff, gift card type ideas, right? Trying to get into digital currency stuff. So then Ethereum launched, and he saw the ability to basically use Ethereum's network as a more powerful application to be able to bring what he actually wanted to do. So in 2017, he brought out a whole roadmap prior to launch of the Veri token. It said everything he wanted to do, including precious metal exposure, which I found interesting in that the SEC later said that he was doing all this stuff with precious metals that he never told anybody he was going to do. Well, that just wasn't true, because if you looked at, you know, his materials from 2017, he's followed that roadmap. The other thing that was a little bothersome to me is the SEC alleged that he never actually developed any of the software that he said he was going to develop. But we did a full demonstration of the Vader platform in the SEC's office over a year ago. And in fact, the SEC told him that he should probably stop doing that, because based on some of the functionality, it may actually be an unlicensed securities exchange. And he complied. So I think it's a little disingenuous, some of the things that the SEC has put in their complaint. I'm a little disappointed in that they felt like they had to go through these types of tactics just to bring this complaint. I'm not surprised, but I'm disappointed at the same time. I mean, for example, they claim that Reggie moved 10,000 ETH just all of a sudden after he got a Wells notice. But this actually was a standard practice every 6 months. And we'd given the SEC all of the company wallets so that they could monitor them. We didn't hold anything back. There was full disclosure from day one. And about every 6 months, Reggie would move ETH out of a cold storage wallet, bring it into a hot wallet for business expenses and development and all of the things that he was doing to develop software. This was standard practice, and the SEC knew it. And in fact, after they saw that move, they contacted Reggie's current counsel and said, "Hey, we saw this move. What's it for?" And it was explained. These are business expenses. This is the same stuff that we've done. But even though the SEC knew that, and they knew that it went into company accounts, they still alleged that Reggie moved those funds into personal accounts. And so that's just an outright lie by the SEC in their complaint. The whole reason they did that was to get an asset freeze, because it's this big deal if they can launch a press release that says that they filed a claim for fraud and market manipulation and they got an asset freeze. It doesn't get headlines if they don't get the asset freeze with it. What was even more disappointing is they gave virtually no notice to Reggie's current counsel that they were going to go and file for that asset freeze. In fact, they gave him about an hour's notice before they ran down to the courthouse without sharing any documents with Reggie's counsel at all. They had a stack of like 3 inches thick of documents that they dropped on the courthouse step, and Reggie's counsel had zero opportunity to prepare to argue against the TRO. So to me, those types of tactics, it's kind of cowardice the government doesn't need to do that. They have all the power in the world in these cases. They can bring a legitimate case if they want to bring a legitimate case, but they don't need to lie. They don't need to use bully tactics. They don't need to do this stuff. Not when the guy's been cooperating for almost 2 years.
Anybody else want to join in? Bill, Preston? Oh, you guys are muted, by the way.
I'll just say I don't have a ton of opinion on this, which is kind of unusual for me. But I will say that, the last comment Jason made about the heavy-handed tactics of the government is something that I think we should all be cognizant of, that the state has a tremendous amount of power, and it shouldn't be used except judiciously. And I'm going to be watching this with eating my popcorn and seeing how it turns out.
Well, if I can add, I think what most people should watch this case for is not necessarily the he said, she said about this, that, or the other. I think what people really need to focus on for this case is that prior to the Very token being launched, I don't mind saying it, I advised Reggie on how he had a great example of a utility token, and I helped him set up to be a utility token and how that needed to work so that it was for consumptive purposes, not investment. And that's not to say that there weren't some things that were said that may have changed that perception by the market. But I think of any of the claimed utility tokens that were released on the market in the last couple of years, Reggie's is the closest one that was released back in 2017, attempting to be a utility token that's actually going to meet that definition. So I think hopefully we'll get some clear definition from the court on whether or not it accepts, how that was set up. And that it makes the decision that it indeed is a utility token versus a security. So I think that's why people should.
Yeah, and I'm just before I go over to Preston and Jason, I back then I disagreed with you, and I tried to explain to Reggie why this is not a good example of a utility token, and he shouldn't do it.
Personally, I think the whole concept of a utility token is pretty specious. So. I haven't seen any examples of a utility token. I think, and it's on a very thin read of case law. So I'm very curious to see how the courts interpret this and it plays out.
Hold on.
Oh.
When Bill uses big words like that, the people out there, they gotta go grab specious. They're thinking like species, aliens. Don't be using big words like that,
I'm tired, bro. I've been up all night working on something else.
$2 word when a 5-cent one will do just fine. He's calling it bullshit, people.
Yeah, bullshit actually was the word that came to my mind.
All right, so let's over to Preston. Preston, what's your view on this? I mean, you were part of a company and you left because you guys were going to issue a utility token, right? ICO. So what's your view on the whole Veritaseum situation?
That's true. The company's investors decided to do an ICO, and I decided to resign immediately. That literally the moment I was told. The company wound up not doing that actually, and wound up doing something else. So I guess I could have stayed, but in the long term, I'm quite glad that I went back into the practice of law. The thing that really gets me about this is, far be it from me to contradict what Jason said about his client here. I don't want to, I don't know the facts of the case. I'm not familiar with Veritasium's offering. I had nothing to do with it. I know it was there. And of course I saw Reggie around in the marketplace. During that period of time, and part of the reason I was so opposed to the concept of ICOs is that I saw this kind of dangerous intermixing of venture capital style marketing with public offering style transactions. So if we look at, for example, paragraph 29 towards the bottom of page 8 of Veritasium's, of the complaint regarding Veritasium, the SEC's complaint, it says here, brochure 1 claimed that Veritasium Inc.'s, quote, potential market literally boggles the mind in that, quote, we get a potential market of $225,520,000,000, which could yield, quote, well over $1 billion in annual cash flow, such that, quote, Ultracoin is valued at over $20 billion, right? So, I mean, those are some big numbers. Those are some ridiculously big numbers. And this is not by any...
and for a platform that the SEC said potentially was just there for basically unregistered security transfer, which, as Jason said, they complied with. So I'm not sure what that meant going forward for the platform.
So when you're selling something, right, you have to be realistic about the representations that you're making with the sale. When the thing that you're selling, if there's a risk that that thing is a security, generally speaking, you have to keep your statements limited to the realm of the factual. And if you're going to make a forward-looking statement of any kind, you need to run it past counsel and make sure that it's sufficiently qualified that you're not misrepresenting the reality of the situation. Another favorite of mine in this was Basis, which has since shut down. And Basis was a stable coin that raised something like $130 million from Bain, Andreessen, all of the great and the good out in Silicon Valley for this algorithmic stablecoin, which was supposed to magically hold, value to $1. And they said, well, if we're used by 5 or 6 major applications, we estimate that we're going to have a market cap of $800 billion. And I read that in their white paper and I was like, this is ridiculous. Now, if you then take something like that or a statement like that to an investor that you sold something to publicly, and the investor then says, hold on a second, you represented this to me, and they ask you to back that up with some factual evidence, and you can't do that, the investor would not necessarily be unreasonable in potentially bringing an action against you for fraud. So one thing about Veritaseum, without making any conclusions about anything, is that it very much bought into the hype machine of its time, and it followed that sort of pattern where crypto projects, because they were crypto, were willing to make some pretty, shall we say optimistic representations about what their products can and can't do. So quite irrespective of whether the things are securities or not, and in my opinion, most of these things are, and so that's why when looking at these projects, I generally nudge people to either keep them out of the United States, or if they're in the United States, avail themselves of the appropriate exemptions or some other issuance pathway like Regulation A. This is just so typical. I've seen this before, and it makes me wonder how many more of these are in. How many more of these enforcement actions are in our future? But of course, I'm not going to arrive at any conclusions. There's, this is subject of ongoing litigation.
And I agree with everything that you've said, and I have counseled many people exactly the same way that you've done. And to Reggie's credit, before he launched this, he came and talked to me and said, how can I do this and how can I do this right to be a utility token? And we spent a lot of time working on that. I think one of the things to Reggie's credit and to Veritaseum's credit is that not a single claim by a single purchaser or user of the Veritaseum platform or a Veri token has actually made any claim of loss or fraud against Reggie.
Oh, I gotta push back on that. I mean, who was actually using the platform for its intended purpose?
I'm sorry?
And how many lawyers in this country take those lawsuits?
Right. Well, I don't understand who was actually using that platform for its purpose. Like everyone was just buying and trading the token. And if you got in early enough and got out at $400 a token, which is now under $10, why would you complain?
So I think one, the platform does work, and is still doing exposures for discounted precious metal purchases, and all that's verifiable. It's not any kind of a fraud. You can purchase gold through Veri tokens and add that to your portfolio. And I don't want to go into all the details because we can jam into the minutia. Unlike the cases that David brings or that Bill brings on behalf of people who have lost, I don't know, and maybe I'm wrong here, but I don't know of a case where somebody has brought an action against Veritaseum for a loss.
Yeah, but Jason, come on, you know better than that. That's not a threshold that matters.
No, it's not necessarily a threshold defense. I'm kind of backing up what you were saying, David, is that there are so many other bad actors out there that there was no reason for the SEC to come out as heavy-handed as they did and make false statements in order to get an asset freeze against a guy where all the funds are still there.
And that's Jason's best point, that now we're back to being in complete agreement. I mean, I can't get over the fact that there's no allegation here of missing money. And, for what the SEC is doing right now, and for what all the government regulators should be doing right now, is going after the people that are low-hanging fruit that just stole the money. Let's clean it up with the case law related to the absolute frauds. Why are we jumping into a gray area? Now, I can argue that I don't believe in utility tokens till I'm blue in the face. There is clearly a small portion of the population who believes they're a legitimate investment tool. But there's so much more that the government should be doing, especially with this type of, I'll use the phrase, heavy-handed language or government overreach, that this just wasn't the one to do it on, is my only point. That doesn't indicate guilt or innocence. It just means that it was a shitty one to come out with for, near the front rather than the back.
I'm slightly. Let me just throw in my 2 cents here. I know I'm not a lawyer and I should just stay quiet, but that's impossible. I'm slightly on the
It
other
is your
side.
show.
Yeah. So David, no, for the straight up fraud stuff, I'd rather have those go through like you and Bill. This is the kind of stuff I want the SEC to get involved with. Now we can argue whether Veritaseum should or should not have been the case, but I want the SEC to challenge this bullshit concept of a utility token, which again, Jason and I can argue this probably even better than we argued Saifedean's book, whether Reggie's token was a legitimate use of a utility token. And I will argue that it absolutely was not. The way I argue that Ripple is not a utility token and it's bullshit. It's not necessary to their ecosystem. So I want the SEC to go after it. Now, if the SEC is lying and they're using, terrible practices, obviously that's bad. I'm not here to support the SEC in their, bullshit that they do to get to this.
Tone, let me ask you a quick question on utility tokens, just for a second. Would you describe a Bitcoin as a utility token?
I would describe Bitcoin as an attempt to have decentralized currency, but it's the only way to do it.
Except you cannot have the Bitcoin protocol without a Bitcoin or
Agreed.
fractions of a Bitcoin, right?
Agreed.
So it is
Absolutely.
necessary for the functioning of that, but it transcends into something else as well. It transcends into currency, storage of value,
Absolutely.
other things, right?
Absolutely.
So at its core, Bitcoin protocol itself is a utility token.
Absolutely.
Now,
Sure. By
for
that
the
definition, sure.
Yes, right? So just like ETH is a utility token because without it, the Ethereum network doesn't work. And the same thing applies to the Veri token. That
No, it doesn't. Absolutely not. Absolutely not.
Oh, because
I will
you're an
argue
expert
this all
trader.
day with you, Jason. Absolutely not.
Okay.
Because
Ethereum is a security. It should have been,
Right.
and it should have been shut down years ago. And
hold on,
Bitcoin would have been
I
if
think
the government actually had
I
it
think
there.
the pre-sales of Ethereum were a security, and Tone and I have covered that extensively. I think today Ethereum or ETH itself is more a currency or a commodity than it is an investment contract.
I disagree with that also.
Because
And-
people consume it
but
within the network and use it as a currency.
But Jason, my other argument is, and I don't want to give it back to Bill on this one, is that sure, you may be able to win the argument that Ethereum is a legitimate utility token. The end result of it is, if Ethereum is a successful project, it will go away because the utility token of Ethereum is not necessary to provide the function of Ethereum.
Utility token is that which is necessary for the running of the application. So ETH is a utility token. However, it transcends like Bitcoin into additional things because it's being used for different
wait. It's a Okay, it's a necessary token because based on how Ethereum was designed, but the
Correct.
concept of what Ethereum is supposed to do does not. It's like saying Binance must have a utility token because it was designed with the utility token, yet somehow for the last 200 years, we had exchanges without a utility token, right? Just because you design something in a dumb
hold on, Tone. For the last 200
utility
years,
token doesn't mean that it's
where
necessary.
you had pieces of paper where people wrote their trades down on a piece of paper.
That's not
and
that.
submitted those trades.
My point went completely over your head, Jason. My point went completely over your head. You do not need a utility token of Binance to build an exchange, just like you do not need the utility token of Ethereum to build a smart contract platform. Okay, they did it for the money. That's the only reason why the Ethereum token exists.
Yeah, I mean, look, I mean, it's an open market. I know you're a Bitcoin maximalist. Maybe this all should have been done on Counterparty and you'd be happy, but it wasn't. It was done on Ethereum, but that doesn't mean that if somebody creates a utility token in order to run a software engine they designed to run on the Ethereum network, that doesn't make it a de facto security. As the SEC and the Supreme Court has said, you have to look at the facts and circumstances of every case individually to do an analysis in order to make that determination. And so the argument from Veritaseum is that this is a consumptive deal. This is, this is Forman. People are consuming it. They're using it for the intended purpose of driving the software. Other people are arguing that it's an investment contract. And I just was trying to say that I think this is going to be a good case to watch, to get some sort of guidance on where that line is drawn by the government, how the Southern District is going to interpret Howey and interpret Forman in relation to the SEC's allegations that utility tokens are or are not securities. And so that's why I think people should watch this case, not necessarily for the claim of any loss or that somebody ran off or did some sort of exit scam or anything else, because that's just not fair.
Well, that goes back to Tone's point. But that goes back to Tone's point. And if that, I have no problem with the SEC doing what they're doing to give clarity. But isn't it weird now that we're going to get clarity on the utility token? So let's just assume Reggie wins for a second. Does this mean we're just going to have 2017 all over again in 2021 when Jason, this gets resolved?
If Reggie wins, I am launching a utility token for my consulting services. I will do this at my next Understanding Bitcoin conference. I will launch it on the Liquid sidechain because Ethereum's not stable. And I will create a Tone token for my consulting services, and I'll let it fluctuate in value.
And Tone, you don't even have to wait. You can do that now because that's called pre.
No, I don't want to be in Reggie's situation. So I'm not doing it now, right? I don't want to give you more money to defend me later when the SEC freezes all of my bank accounts for doing it now. So I'm gonna wait till Reggie wins. So good luck.
No, that's what I'm saying. I mean, we're all going to be back in 2017 where everyone's selling utility tokens again. Talk about what a crappy universe that would be.
All right. I'm not going to get into Forman. I actually haven't read the whole Forman case yet. Adela is about to join us. But Bill, sorry, I cut you off.
This is a really good discussion. And I'm glad, since I'm so tired, everybody else is monopolizing this podcast besides me. But I really want to tie in together what Jason and Preston said, because I think they're talking about two different things. And I think that they are almost talking past each other. And Preston is talking about where you have VC type fundraising activities. And Jason is talking about where you have specific features of a particular token. And I don't think we're going to get the type of clarity that everyone expects with respect to utility tokens from this case, because here you can't divorce the token from the offering, right? The raise and the token are inextricably linked in the SEC's petition. And because it's focusing on the raise, we are getting into the fundraising applications and the fundraising scope of the SEC's jurisdiction. If we were to take this Veritaseum token, and again, I don't know much about it either, if we were to take the Veritaseum token a year from now and look at it in isolation away from the raise, I think we might have more clarity and facts about whether or not a utility token exists. But every time that you have a raise coupled with a token of whatever type of feature that might be, I think it's very difficult to argue that the SEC doesn't have jurisdiction and that it's not.
Well, let me just tie in a raise with the utility for something that happened in the marketplace a couple of years ago, and I'm sure this is going to cause a little bit of blowback. Does everybody remember when Tesla was taking $35,000 deposits on the Tesla Model 3?
Yep.
Right. So was that a securities offering because they were taking payments for pre-orders for products to be delivered at a later date? Does that make the Tesla?
Well, maybe it is when you talk about Musk saying that the Teslas are like explode in value because they're going to be self-driving taxis. Maybe something like that as a securities. But I think that's a bit of a, I don't want to use the word canard with you, Jason.
Right?
No,
Right? I'm a big
no,
fan
wait a
of
minute. No, to me, that was the same thing that Indiegogo does. And what's the
Right.
other one?
So
Or
I think
wasn't that also the pattern in Sobieski, which is the California risk capital test? So there they were selling country club memberships. So conceivably, yeah, that could have been on the right. That could have been on the wrong side of the line in the state of California.
Yes, yeah.
You know?
No, that's right. I remember the country club and I remember those tests, the risk capital. The difference between, I think, the country club scenario versus this scenario is one, it's kind of a hot topic these days with cryptocurrency and with tokens. But I just can't help but look at this one, and I admit that I'm biased because I worked with Reggie on the creation of this. And yes, there were a few things that were said during his offering period that I wasn't involved in that I wish hadn't been stated to the public. But you know, at the end of the day, he did what he said he was going to do. He continues to do what he says he's going to do. And going back to my original statement, the heavy-handed application by the SEC here in order to try to get their asset freeze when there was no risk of loss, when it was business as usual, when the SEC made materially false statements in their asset freeze motion, doing it at the last second without any notice to opposing counsel to prepare. These types of actions, these heavy-handed actions, for a guy that had been cooperating for 2 years ongoing. I don't know if you guys know this or not, but Reggie sat for five depositions with the SEC in the last 2 years.
It's totally scary stuff, Jason. I mean, it should make anyone scared of any type of regulator and the power that they hold.
Well, and you guys have seen me or maybe heard me speak at conferences. I say it all the time. The SEC is going to show up. They're going to issue an asset freeze before you even know a complaint is filed. You know, they're just going to, you know, tie your hands, and that's what they've been doing. But in this case, this is the first time in this space I've seen them do this after working with somebody for 2 years that had counsel, that was in the process of doing all of these things and cooperating as much as Reggie was. That's
let's get a Della in here.
Isn't that a perfect segue to Bitfinex? Because isn't that what they did in Bitfinex?
Yeah. Let's get a
Can you guys hear me?
Della in here, and then we'll go to Bitfinex.
Hey guys, so I just want to make a few points. You know, one, I want to speak about Reggie's character. I've worked with him before. I find him to be very straightforward and pretty truthful. You know. He's a straight hitter. Secondly, I'd like to speak about Jason's veracity, which, you know, hi, Jason.
What's up, Dells? Rihanna says hi, and so do the kids.
Hey. So Jason's been talking to me about this for what, over 2 years now, Jay?
Yeah, off and on, yeah.
Yeah, you've always held the same position, you know, so I really just want to say that. Another thing is, you know, the power of administrative agencies. You know, they have vast discretion to implement complex schemes. And, you know, when that is enabled by courts, we should all be concerned. And whether or not Veri is a utility token or not, I think that's almost ancillary at this point, because, you know, we're talking about some very concerning things. And my last point is, like, who has been harmed? Like, where are the victims?
But wait a minute, it's been discussed on the show many times that you don't necessarily need victims, right? I mean, the thing is, by Reggie doing what he's doing, he may not have any victims, and he may build a great platform, but he's creating an environment where 1,000 other people are going to follow his lead in creating an ICO token where there will be victims, because that's basically the point.
I don't think it's fair to blame Reggie Middleton for that.
No, it's not.
Right. Thank you. And I was going to say the same thing. If a guy does it right and somebody comes along later and commits a bunch of fraud using the correct template.
Well, wait a minute. No, I'm not. Let's take it. Wait a minute. Let's take it before Reggie. Let's take it to Ethereum. Just because Ethereum didn't run away with the money, that's what caused the entire 2017. if Ethereum ran away with the money or the platform never launched originally, we may not have this insanity of ICOs. Actually, I know we wouldn't because they're building on top of Ethereum.
You and I talked about that a lot, and I've been very critical of the SEC for not going after them for their SAFT agreements, right? For their ICO deals.
Let's
The thing
talk about
Reggie is that Reggie flat out sold a token. He didn't sell a promise for a token. He flat out sold it, and he had existing products and services, and people actually redeemed them for that. So unlike
that is so debatable. That is debatable. Like maybe 1% of the people redeemed that token for services, and I doubt it was that.
No, but what's not debatable is he actually had products and services that were available at the time that he launched that people could redeem the token for.
Hey, David, we can all see you yawn. You want to say something?
I mean, come on. That's like the Kick saying they sold the Beaver stamp. I mean, come on. I mean, I'm a tone on this. That's ridiculous. I mean, like, oh, they sold $150 million, but you could buy an animated GIF and, use their token for an animated GIF. You got better arguments to make. But I think that Jason's point about like overreaching and people without notice is a nice segue to Bitfinex, what's happening there, because the government ran to the courthouse to get a
David. Before you go on to Bitfinex, I'm gonna say goodbye and thanks everybody. Pleasure talking with everyone. I hope to be able to join you guys again soon. But I got to bounce, as you can see. It's back to school dinner night. Say hi, everybody. And we'll talk to you all soon. Take care, everyone.
Bye, Jason. We can do a whole episode where you and I debate whether like things like Veritaseum are a legitimate utility.
I'm all for it. I'd be happy to dive into that and work with you on that, Tone. You just let me know and we'll get it scheduled. All right.
We should do a whole episode specifically on the concept of utility tokens and really do a deep dive.
No, I'd be happy to do it because I can talk about it from the technical standpoint. As Adela's aware, I've worked with a lot of companies.
I was just gonna say,
on coding that. Yeah. Adela should be there too because we've worked on that a lot. All right, guys. Cheers. Take care.
All right. Bye, Jay.
Bye, Jason. Oh, and the one thing I wanted to say to Jason real quick is the whole Tesla example. Tesla never claimed that the cars that they're selling is a utility of the Tesla company. I mean, that's the ridiculousness of these utility tokens sometimes. Like if Tesla said that we have to sell these cars ahead of time because cars are going to be the utility, to make our company work. I mean,
well, it's become a buzzword, just like blockchain has become a buzzword that's almost meaningless, right? We don't really know what it is, whether it means anything from a legal perspective in the context of crypto assets, or it's one of these things. And I think I was commenting on Paley's Twitter, where he was saying, just because you have a big law firm and oodles of money to spend on something doesn't mean it gets you out of trouble. It's been my perspective, especially in the crypto space, that it's all these big firms that are causing all of these problems by trying to build Rube Goldberg devices to escape, clear statutory principles. And it's like the guy in the cartoon with the kitchen with the mousetrap and the toaster, and it's got the ball that rolls down, it lights the candle. I mean, it's a complex way to try to avoid the securities laws, basically. And I'm skeptical, to say the least.
All right, so let's move over to the Bitfinex case. So it looks like the New York Supreme Court dismissed Bitfinex's attempt to get the case thrown out. Let's go over to David. What do you got for us on this one?
So this one is the court denied the motion to dismiss. Bitfinex wanted to walk away, saying the court had no jurisdiction, and the court basically said, nope, you had New York customers.
Yeah, of course they did.
We're going to hear this case, and Bitfinex immediately filed a notice of appeal. And this kind of rolls into what Bill was just saying. Sometimes having big, powerful law firms, it doesn't always, Bill was saying some of the big, powerful law firms created this. Well, in this particular case, I think the big, powerful law firm is doing their client a disservice, because the big, powerful law firm, by fighting this so much and taking public stances which are going to ultimately harm their client, is problematic. Here, they said we wanted to work with the government, we wanted to work with the AG, I think someone released a statement today talking about the accounting. Someone else released a statement. What is it? Tether is now 72% backed. All of these statements are going to come back to bite Tether in the ass eventually. I think that a quieter, smaller, more reserved approach, if they were truly legitimate, would have been the way to go. Because if you're going to ultimately fight and stand by your product, working with the regulators is the way to go. Shitting on the regulators is not. It's why I'm a big fan of the companies who like Coinbase, the Gemini, who are working with regulators. I think in this space, those that want to work with the regulators are going to be the ones that thrive. And I think today was a good example of we're going to get to see a lot in the public space. And I think this is a good step in the right direction to show whether or not Tether and stable coins are really as stable as they claim, or they just stole a good name.
Anyone's welcome to jump in here.
No, I think that's spot on. One of the things that I'll say this case is all about, or this opinion that came from the New York Supreme Court is all about, is jurisdiction, right? And this tends to be the default. The first challenge that anybody makes when they're in trouble is to go to a court and say, you don't have jurisdiction over me. What that means is, what they're trying to say is that the court doesn't have the power to impose any kind of a sanction or liability on someone. And what we got from this opinion is that jurisdiction is pretty easy to establish, especially when you have some sort of a tangential conduct with a state. Now, what was addressed, or a country, right? So there's concepts of jurisdiction either in federal court, what if you're dealing with something that is within the United States, or state jurisdiction, which is within a context within a particular state. And so what Bitfinex was saying is, listen, we don't have any context with the state of New York, so you guys don't have any power. The state AG doesn't have any power under the Martin Act, which is one of the New York state securities laws, to investigate Bitfinex. And the court said, well, that's, without going into detail, because it's really not that interesting, it was that, of course, you have contact with New York. Of course, there's New York residents. You had an executive who was, making company decisions from the state of New York. So while it tends to be the first argument that defendants often make, you have to be pretty clear that there's nothing going on in a state, and this is, like David said, one of those standard playbooks by big law firms that expend a lot of money. They're very valuable if you can win and say that a state doesn't have jurisdiction over you, but it's also hard to accomplish. And I think this has probably been, it's hard to spitball the strategic decision making of other counsel, but it certainly has not paid off in this instance.
Hey guys, I'm out. I gotta go get dinner with some clients. Go enjoy.
Oh man, I wanted to get your take on the whole Ripple situation, but that's okay. Well,
next time, man. Have a good night, everybody.
All right, later, David. Preston, what do you got on this? Maybe does anyone even know what the hell happened to what's that company, the Crypto Capital? This whole case is just insane. There'll probably be a movie involving all of this one day. Preston, go for it.
Yeah, so I mean, to the point that there are a lot of contradictory messages coming out, I think that really stands out in my mind more than anything else. We hear a lot of sound and fury coming out of Bitfinex that the Attorney General has exceeded her powers in conducting that investigation, and the court actually hints towards that in their or in its decision. But basically, they then go through the relevant provisions of the CPLR and Civil Procedure 101 test of whether there are sufficient minimum contacts with the state. And they basically say, listen, at pre-discovery, the party opposing dismissal need only show that facts may exist, whereby to defeat the motion. It need not be demonstrated that they do exist. Those facts being that there might be circumstances where Bitfinex or Tether operated in New York State. And clearly those have been alleged. So I'm not really seeing where that was going to work out in Bitfinex's favor. And then if we look and go to the minimum contacts analysis, so this is the constitutional due process issue. Once again, the issue is whether we don't need conclusive evidence that Bitfinex and Tether have been operating in New York State. We just need some evidence that suggests that they were knowingly conducting business in New York State. And whatever Bitfinex is going to say, I strongly suspect that the word of the Attorney General of the state of New York, with the appropriate statement of truth given when they submit their pleadings, is going to be at least a little bit persuasive on that question. And Bitfinex is basically trying to, in order for them to succeed on this motion, the Attorney General would have to have been completely falsifying the allegations that have been made, that form, the jurisdictional basis on which the court can adjudicate the matter. So I think that, it doesn't look great for Bitfinex. Pally pretty much put it very succinctly. It does, and I don't know. It strikes me that maybe an earlier attempt, or several years ago, the company should have been focusing a little bit more on its U.S. compliance picture. But at this point, when you're arguing seemingly doomed motions to dismiss, which the other guy, their counsel had to do it. I would have done the same thing. You're negligent if you don't. But for the rest of and who knows what image they're trying to put out. But for the rest of us, it doesn't look great. As to crypto capital, I mean, obviously there is a concurrent federal criminal investigation related to some banking arrangements in relation to which it is alleged that Tether has some involvement, or tangential or otherwise. Obviously, we don't know a lot more than what's been in the unsealed indictments that have come down for, I can't remember the name of the fellow who just got arrested for it a couple of months ago. But yeah, that is clearly going to be conducted in complete secrecy until such time as they're ready to make additional moves. So it would be really improper to speculate as to what exactly is going on there.
All right, Bill, anything else to add? Maybe you guys want to...
I will just say I have to go as well. I have some co-counsel finishing up a filing in the autonomy ICO class action. So that's due tomorrow, and I need to make sure that we get the class properly represented on that. I will hope that I can pick all of this up with everybody in the next few weeks, and we do another show. And I really appreciate, as always, the opportunity to come on and chat with everybody. I learn as much as I say every time I come on the show.
Yeah, Bill, thanks for coming on. And yeah, so Gordon Einstein and Drew Hinkes may still be joining us in a little bit. At least I'm hopeful. I know Gordon had like last minute client call, and Drew is hopefully will come in. But yeah, so Preston, if you got a little more time, let's talk about Ripple. I love talking about Ripple. The Ripple army loves me talking about Ripple. You're still muted though.
Yeah, let's do it.
All right. So, you know what? I just realized, I keep trying to read this article, and I'm not exactly sure what this was, right? So, a new amended complaint against Ripple draws on the SEC's framework for digital assets to outline how XRP might be a security. XRP is definitely a security, and I'm just waiting for the SEC to figure that out and somehow. But that's the thing, right? But the SEC is not the ones that are going after Ripple for being a security. This is a class action lawsuit from some guy, Vladi Zakinov, and we covered this before, and the guy basically lost $300, right? So the entire case of Ripple being or not being a security rests on the defense counsel of a guy that lost maybe a few $1,000, right? I mean, this is the insanity of it all. And can you give us some more background on this? If you are a little more familiar with this case than me, you just send me a link. Should I pull that up?
That's just for your sort of own edification. I actually wrote about this particular development.
Well,
case.
so I'm actually really pissed at the block because they delete their tweets. Like one of their guys had this giant Twitter thread pointing out all of the allegations of the C-level managers of the Ripple Corporation and how they were pumping this token in the early days and telling people how it's going to go up in value. And then they completely backtracked from everything they said. And this entire Twitter thread is now gone because the idiots at the block, no offense, Pally, keep deleting their fucking research.
Well, we don't know. I mean, we don't know why it was deleted. Maybe they got hit with a cease and desist. You know, who knows? Anyway, so this action here, the XRP action, is pretty straightforward. Basically, it's being alleged that XRP is a security within the meaning of the Howey test and a similar test known as the risk capital test, which I don't know off the top of my head, which is a California specific test, which basically says that if people, let's actually look it up. Let's see if they put it in the risk capital.
But here's the thing, right? Like I don't understand why some random guy has to bring this case of Ripple being a security and not the SEC itself.
So the SEC, we don't know. I mean, that's a really good question. Why the SEC has chosen to embark on the litigation it has and not embark on the litigation it hasn't. That's a question that a lot of lawyers have asked themselves over the years. They've asked, well, there are certain companies which shall remain nameless that have been responsible for multiple ICOs being launched in, the Eastern District of New York for the last couple of years. Why hasn't any enforcement action been taken place against them? EOS, for example, was a $4 billion ICO. Why hasn't anything been done about that? So it's kind of hard to read the tea leaves without knowing at what phase. The commission has 5 years from the most recent instance of whatever the alleged offense is to go and enforce and bring an action. And if they're running up against that deadline, they have the ability to go up to whoever they're investigating and say, listen, sign this tolling agreement and agree to put back that date. Otherwise, we're going to bring the action against you now. And oh, by the way, let's sit down and start negotiating, which everybody's always going to do. So it's not like we're going to hear about everything that's going on behind the scenes. What I have heard is that a very significant portion of the federal regulatory apparatus is focused on cleaning up the crypto and ICO space. That's both criminal and civil, so it's the SEC and the Department of Justice. So that's what I'm hearing on the grapevine, is that there's a lot of investigation going on. But what I'm not expecting to get confirmation of is who's being investigated or why, because those companies that are collaborating and cooperating with these investigations obviously are going to be subject to gag orders by the SEC. And if they start shooting off their mouths, the commission is going to start becoming very unpleasant to deal with. So they're not going to have any incentive to tell anyone. And it'll be treated really as a state secret by the company until such time as they announce their settlement, such as it was with the we had in the brief before the call, the Simply Vital Health. There we go. Consent order, which came out on August the 12th, where basically one company just said, listen, we threw up our hands, we negotiated, we wrapped it up, we're all done. Nobody knew about that until now, and that's been going on for over a year. So with regard to Ripple, if there are discussions going on behind the scenes, with the SEC, which I don't think there are, because if there were, it would be probable that we'd be hearing from the class action litigants to go get disclosure of those. That would be my guess. So my guess is the SEC.
It depends on how good those lawyers are of this class action lawsuit guy.
I don't. So it's Taylor Copeland. I mean, he's not a slouch.
Well, I don't know. This is your domain. So I hope he's good.
I mean, he's not a slouch, but basically this is how class actions work. They go and they find one claimant who's a member of a larger class. The larger class consists of thousands of people. They then go out, they engage in an exercise to identify all the various members of the class. They bring the action, they win or lose. The lawyer takes 30% of the winnings because lawyers are ordained by God to that money because of the wonderful, valuable function they perform for society. It's why they've been so well respected in Western society for so many thousands of years. So it's a joke, obviously. But anyway, that's how that works, right? So they identify one claimant, they then bring the action. It's kind of a race to the courthouse to bring the right claimant to the courthouse so that you can then go and shepherd that action for all of the other similar claimants or claimants who are similarly situated. So anyway, this action was brought a while ago, and basically it's been argued that that Ripple is selling securities. I believe they said something to the effect of Ripple has engaged in a years-long rolling ICO where they continue to sell these things to the public in order to fund their ongoing operations. That's the allegation. If that's the allegation, and if the SEC agrees with that allegation, it might make sense why the SEC hasn't done anything about it, because every time that Ripple sold these tokens into the market, under that argument, you're looking at a brand new cause of action arising. You're looking at a new limitation period commencing every time they're selling these things into the market, right? So that's one potential explanation for why the SEC hasn't budged. It's because they don't need to, because every time Ripple is selling a tranche, in their opinion, they've got a new cause of action that they can go after Ripple for with respect to the sale of unregistered securities. Another view they might be taking is it might be better to let this private litigation play out and see where it goes, although my suspicion is that this will wind up settling out of court. That's my guess. But in terms of the recent development, so what we're looking at here, what has happened is there is a complaint, right? So the complaint is, right? There is a amended complaint that has been made. So Taylor Copeland submitted a new complaint, which basically says, hold on a second, we needed to update what we said. And in that amended complaint, what they've done is they've taken the SEC's token framework that was issued a couple of months ago in conjunction with, there was some aircraft company that was selling tokens that got a no action letter.
Right,
because basically
right.
the token,
Keyjet.
Right. So those tokens were basically coupons, right? You bought them for X, they were redeemable for X. There is no expectation of profit or appreciation because you're basically pre-funding.
All right. The whole point of that token was so that people can pay for their airlines while the bank is closed.
That sounds like a great use case in countries that don't have credit cards, like, or for airlines that don't take credit cards. But anyway, so that's a token, right? At the same time, the SEC.
Yeah, that's a utility token. I have no problem with that.
Right. Well, it's just a coupon, right? It's not a utility token. I think the idea when people talk about utility tokens is that I think what they're talking about is something which is like a hammer or a pair of sneakers or something which is this kind of far distant crypto utopian thing where you imagine you have some digital object which you use much like you would use a pen or a phone or anything else. So that I think I wouldn't go that far with this. But anyway, it's a coupon, right? So at the same time, the SEC issued this token framework. I read over it. I'm not entirely convinced by it because I think the token framework struck me as something which was designed to, I'm a very conservative practitioner. My advice, I was very against ICOs, as we mentioned at the beginning of, of this discussion. When a company I was associated with decided, considered doing one, I said, this isn't for me, and I left. Similarly, over the course of my practice, I've had the opportunity to advise people on these things. And generally my view has been very conservative. As people who read my blog will know, for a long time, I've said, listen, if you're going to make the argument that something's a utility token at the pre-functionality stage, or when you're selling things under a SAFT instrument, if you don't also consider that what you're selling right there and then is a security which needs to be subject to an exemption of some kind or be registered with the commission, you're treading on thin ice. So something may well be very useful, and may well be a utility token associated with a platform that has some functionality. But in the view of the Securities and Exchange Commission, it may also be a security at the same time. So that token framework, what has happened here is that the SEC came up with a token framework. And then what happened was the plaintiffs in this action decided they were going to include the references or some of the ideas that were contained in the token framework in their pleadings. So they were saying, listen, well, guess what, Your Honor, the SEC thinks that these things are tokens. And I'm going to pull up the document, which I don't have available right now.
You want to, is this the document?
No, the document is linked in the CoinDesk article. So if you go to the CoinDesk article and then scroll down to the language amended complaint in the second paragraph.
Wait, roll one.
Yep.
Nope, that's Reggie. Oh
So go to the block link. There you go.
yeah, this is the CoinDesk article. Okay, which link?
Second
This one?
paragraph. Amended
The
complaint.
amended complaint.
Yep. Open a new tab. All right.
Oh, that was the same thing. Okay, this is a different one. Okay.
Yeah. So if you scroll down to page 6, or yeah, so it's page 6 of the PDF, page 5 numbered.
Okay.
So it's paragraph 10. You'll see language there. The SEC's Strategic Hub for Innovation in FinTech has also published the framework for the investment contract analysis of digital assets.
Yeah, which I read like 3 times. It's right here.
Yeah. So
the links, all these links are in the video description, by the way, and I'll add some of the ones that this one is in there. So if anybody watching it wants to pull it up, it's all in the video description. Sorry, go on.
So that framework, they then basically say, if we go down, it doesn't get mentioned again until page 29, and under heading F, XRP is a security, right? And so there they talk about the framework a little bit in paragraphs 121 through 124, but then once you get to 125, you're looking at, it immediately jumps into the common law test, right? So the investment in money in a common enterprise with an expectation of profits arising from the efforts of a promoter or a third party. So basically the bulk of the argument then is that's the Howey test. And that runs from paragraph 125 all the way down to 139. And then at paragraph 140 again, it goes back to the framework. And it says, while the framework lays out a number of characteristics informative of whether the reasonable expectation of profits are met. So for example, the opportunity may result from appreciation in the value of the digital asset. The digital asset is transferable on or traded through a secondary market or platform, right? So those are indicia, in the SEC's view, of whether something falls within the tests. So when they're looking at a token, they have told the world with this token framework, when we're looking at the crypto markets, we've taken these historical common law tests, and these are the factors that we consider are important for assessing whether something fits within one of the tests and fits within the common law tests. But the importance is not in what the SEC thinks. Ultimately, the question is whether the court agrees with the plaintiff's assessment that the XRP fits within the 4-prong Howey test. And if they do, then that's that. Then that's where the question that we've all been asking is. So if the court says, listen, XRP is a security, plaintiffs, you're 100% dead on right. If it gets that far, if they don't settle first, then that's that. Then Ripple's up a creek without a paddle. So basically, the only thing that's happened here is that the plaintiffs have amended their complaint to say the SEC kind of agrees with us. So as I say,
and I actually like that a lot. And by the way, so here's that article from the block where they did all the research, and then here is the website. Sorry, I know I'm interrupting you, but so the tweets have been deleted. I had found, or somebody had found for me on Web Archive, that Twitter thread, and I'll post this link in the video description as well. Right now, this link is in the live chat. And the last time I looked at this Web Archive, it actually had all of those tweets and their pictures, because they literally went back years and they looked at all publicly available statements from Ripple's, C-level managers, and they pointed out statements like this, where a C-level manager says, for every penny the price of Ripple goes up, the notional value of Ripple goes up by $600 million. I mean, that's probably a factual statement. But there were so many statements from the SEC, from the Ripple C-level managers that are basically, and this was the thing in that token framework, this concept of an AP right there, active participant. And this is someone involved with the project that says things to create the idea that what they're buying is going to appreciate in value. And there were clearly multiple APs, and I would have focused on that if I was the Ripple lawyer.
I mean, so when they're talking about APs, that's actually straight from the Howey test, right? So it's a promoter or a third party, right, or the efforts. So it's someone other than the investor. So that's just shorthand, the SEC's shorthand for referring to the entities that they're going to be focusing on when they're running the HOE analysis. So I mean, that's really the only big development that's happened in the Ripple case. It's not really a big development at all, I think, was my point in the blog post. It's just that you have a plaintiff, they've brought an action, they've amended their action to say, listen, the SEC, in our opinion, agrees with us using the factual matrix that they've designed to assess whether something is or is not a security. And Your Honor, we trust the court will agree. And so now it's really over to the court to determine, the pleadings. I don't know if this is a jury trial or not, but let's see if, I don't know. I haven't really followed the case that closely. But anyway,
Of all of, like everyone always does, like no one wants to be on a jury trial. Like I will never be accepted in a crypto case to be a juror because I know too much about the space. But if there was ever like a case that I would like do anything to be on the jury, it's this one. But yeah, hey, so look, so I can't read a document of like 300 pages, right? Like I don't know how the hell you lawyers do it, but I'm pretty sure in this document they have gone back and just like the blocks research, they found all of these statements that clearly make XRP a security, and that's why I would love to get my hands on that. Like I really thought that the web archive version of that Twitter feed from Mike Dudas would still be there. It's possible that Ripple hit them with a lawsuit that they can't talk about, and they had to delete all those tweets, and somehow managed to delete it from the webarchive.org. But I don't know. I mean, that's the whole point of webarchive.org, is so that it doesn't get deleted from the internet. So I don't know how the hell that worked out.
well, go scroll. You're on the May 13th, 2019 capture. Go back, because there have been 34 of them. So go back to 25th of December.
How?
Yeah. So click on captures. Click on 34 captures.
Yeah, so I don't really know how to use this thing. I just I'm an idiot.
All right. So save 34 times. Go scroll down, and go back. Click on 2018, upper right hand corner of the screen. Right. Scroll down. November 25th.
Right. That was before the article was written. That was the
Was
I guess that was the very first. Yeah. See, look at this.
All right. Then go to the next. Here we go. Do this.
Yeah.
Right, then
but
go to the next. You can scroll. So check out January like 20th or something.
I think they're all going to be the same. There's a few
Are
of them. Yeah. Like
maybe it's archive.is that has it rather than archive.org.
Well, I literally saved the link into. I saved the link that worked, and now it doesn't work anymore.
Well, go take that link and put it into archive.is.
What is okay? Explain.
So archive.is is just a different website.
Okay, so I can just take this. Oh, okay, I got you.
Okay. Search the archive for saved snapshots.
Sorry, why am I saving that?
8 months ago. Here we go.
Oh, I got it. I think I got to it the wrong way, of course.
Bam.
Right, here it is, guys. Here it is. How do I send this to people? How do I how do I capture this so it doesn't go away again? Anyway, read this.
It's not going anywhere. It's on archive.is. It's mirrored.
Okay. So at least it's there. Right. So this was the Twitter feed. All right. So check that out. I'll throw this. I'll find a way to do it. So here it is. And this was a really good, like look back into a lot of this stuff. I mean, the Ripple thing is so bad. I had like other links when it comes to, where was it? Nope, not that. Not that. This here. So unfortunately, whoever was running this XRP chat thread, I mean, this is a Ripple lawsuit. So this is like the history of all their lawsuits, and it just keeps track of everything. And so again, these links are in the video description. All right. So clearly the plaintiffs are trying to convince the court that Ripple is a security. Now, I want to touch on the statement that you said earlier. If the court agrees with the defendant, with the plaintiff, that Ripple is a security, and it's in violation of what I mean, and what the SEC said about the framework. You called it, up a creek without a paddle. So what happens to Ripple if the court? I mean, obviously they're going to appeal, and if that happens, they'll appeal. I mean, I don't want this in the Supreme Court, but it can probably get there because Ripple has $1 billion. Literally, their lawyers are former heads of the SEC. That's Ripple's lawyers. Like Mary Jo White's one of the lawyers. Like their lawyers are literally heads of the SEC. I mean, if you get paid enough money, sure, you'll argue that it's not a security, even as the head of the SEC. If she was on the other side, it would be a different story. Everyone's for hire. So if this thing obviously is going to go to appeal and appeal and appeal, but if it is ruled a security in the year 2032, what happens?
I don't think it's going to get that far because I think that they're going to settle. I don't think they're going to take this all the way up to the Supreme Court. If they do take it all the way up to the Supreme Court, my own hunch is that they're going to lose. And if it were found to be a security, then the plaintiffs have statutory remedies for sale of unregistered securities. And so they could get damages and interest, right? So that's what they would get. That would then create grounds potentially for the SEC to bring a civil enforcement action using the precedent that had been created against Ripple Labs, and they would have a really solid piece of case law to fall back on, and rather than sitting there and having to do all the work in making that argument for the first time, it would make their jobs a little easier. And then the question would be, had Ripple violated Section 5 of the Securities Act in 1933 pertaining to the sale of unregistered securities, right? So then the SEC, if they won, they could impose disgorgement, civil penalties plus interest if they so chose. Disgorgement being basically an equitable remedy of restitution or unjust enrichment, where Ripple would pay back all of their profits that they had made. So that would be potentially very damaging to Ripple Labs. But again, that's really super, super, super contingent on a lot of things happening that have not happened yet. Chiefly, XRP has not been found by any court to be a security. The Securities and Exchange Commission hasn't brought any action or commenced, as far as we know, any investigation into XRP being a security. And so far, we've got a plaintiff who claims that it is, and at any time, Ripple and that plaintiff could decide to settle, and that would be the end of this action, and it would be up to someone else to bring a private action in order to arrive at that determination. So from Ripple's standpoint, they're playing for time. They have a crackerjack legal team that really knows what they're doing, and that's that. And so this development this week is simply saying that as I said in my blog post, I said, look, this is a sanity check, right? So when those of us who adopt a more conservative approach to advising our clients look at a situation where a company has been more liberal, and for example, your client then knocks on the door and says, hey, those guys are doing this. Why can't I do this? What's wrong with you? Why are you why are you ruining my fun? And you say, well, listen, I don't want to ruin your fun, but that what they're doing is against the law, in my opinion. So maybe you don't want to do that. Well, and they're doing it, and they're doing it, and they're doing it. And there are a lot of lawyers who have turned down a lot of business by a lot of clients because we have refused, under any circumstances, to sign off on the utility token argument. And we have said, listen, if you're going to be selling tokens, and that sale is going to involve the United States, you need to file a registration statement or get an exemption from registration. And people have regarded us as fuddy-duddies and as hyper-conservative and as difficult to deal with and as fill in the blank and as anti-crypto and as whatever. And then when I see Taylor Copeland Law in this action, which they're bringing against Ripple, say not only do we think this, and not only is this our reading of the law, but we also think it's the SEC's reading of the law. I find that very reassuring because it tells me that the position I've held consistently for 3+ years, which I've done in the face of, I had to leave my job, go back to law school, take a year and a half off work, take a bar exam, and then wait another 4 months to get sworn in as a result of my decision not to jump into the coin markets. That for me is kind of reassuring to know that I wasn't crazy in making that decision and that I made a good call. So that's my own view of what this is. It's a sanity check. It's nice to know that there are people who agree with that view. And it tells me that, as an attorney, I'm maybe not that far off the mark when people walk in my door and they ask me for advice. So, and any other attorney who thinks similarly, they're not too far off the mark either.
Okay, so to me, I'm actually surprised you said how this whole thing that's going down now with Ripple is not interesting. To me, this is very interesting. I really want to pay attention to this. If they do go to court, I would love to be there in attendance to watch what's going on. I'll have to make sure I try to keep my mouth shut, or I will definitely get kicked out at best. But here's the thing, right? Here's one more thing that you didn't mention, right? So, God, I hope they get deemed a security. If they are deemed a security, doesn't that mean that every single exchange that is not legally allowed to trade securities has to immediately purge all Ripple trading, which includes Binance and Coinbase and anything else?
Yeah, that you make a really interesting point. There have been some questions, again, among the crypto legal community. The lawyers all know each other and we all talk. And so there have been some questionable listings on certain exchanges as of late relating to coins which had a very major ICO, which was conducted very majorly in the United States, for example. And those questions are how, given what we are starting to see coming out of the SEC, how are these exchanges getting comfortable with the fact that they're not listing unregistered securities? I'm not going to name what the exchanges are. I'm not going to name what the tokens are in question, but I just will say that because yes, if you are trading or operating a venue that trades unregistered securities, or securities, in fact, of any kind, you need to be a national securities exchange or an ATS. And if you're not one or the other of those things, as indeed most of these other exchanges are not, then you are violating the provisions, I think it's Section 5 again, of the Securities Exchange Act of 1934. So that's a very serious question. We haven't really, again, seen the commission doing a whole lot about that. And again, the only thing that I really can conclude is that they're probably investigating the coins first, and then the status of the exchanges is really contingent on whether the coins themselves are found or determined to be securities. If XRP is found or determined to be a security, then I think it becomes very difficult for an exchange to list anything other than Bitcoin at that point, unless it's a national securities exchange in the United States.
Yeah, so I'm really waiting how this shapes out, because I think all of these ICOs are securities, and if they are, they can go to the pink sheets, right? They can do what GBTC did, and then you can trade them. But like the whole point to Ripple is it's a bunch of anonymous trolls. How many conferences have you been to, Preston?
I go to maybe 1 or 2 a year max.
Oh, that's it?
Yeah.
I go to about 40 a year, and I'm probably on the low end. I have never met a person from the XRP army. Ever.
You're right. Neither have I.
Never. I've never saw people wearing Ripple shirts, never saw people wearing Ripple hats. All I've ever seen is anonymous Twitter handles.
If I held a lot of Ripple, I probably wouldn't wear a Ripple hat either. To be fair, that's not...
The Litecoin people still doing it, so are the Ethereum people.
Yeah, but Ethereum's a little bit more of a religious organization. And, so I can kind of see that. If you want to know how deep my conviction goes on ICOs, I was offered, because I was in London at the time when the whole Ethereum thing was going on, like very, very early stages. And one day I got this email from one of their guys in Canada. And the email says, "Dear Preston, pursuant to our arrangement, we are allocating you 13,000 Ether from the pre-mine, just like a couple million
Wow.
bucks." Yeah. So I took one look at that email and I said to myself, I see what you're doing. It says pursuant to our arrangement. I respond and I say, listen, thanks very much for this. I'm grateful, for the offer, but we have no arrangement. We never have, and you can donate my allocation to the Ethereum Foundation. I'm not interested, and I'm really happy I did that because it means that I
Because
don't.
if that sucker gets subpoenaed,
If that sucker gets subpoenaed, one, two, I don't owe Joe Lubin anything. And that's a really great place to be in,
Yeah.
as far as I'm concerned. So
okay,
that's how committed I am to not getting involved in this stuff.
so here's the thing, right? Let's say that sucker got subpoenaed, and so you never had any arrangement, right?
Right.
So if that sucker gets subpoenaed because Joe Lubin, ran away and pulled a big Vern, which I still expect a lot of these billionaires to do, and that gets subpoenaed, and now the SEC and whoever is basically at your office going, well, we know there was an arrangement. You took the Ethereum. What was the arrangement? Like, how do you prove there wasn't one? You're totally screwed.
I still have my email.
No, you have the email that you accepted the Ethereum for the arrangement, but if there wasn't one, how do you prove there wasn't one?
Well, I responded to his email and I said, thanks for this.
No, I'm talking about if you took the Ethereum and you
Oh,
didn't say that there wasn't an arrangement, but there actually wasn't an arrangement.
Yeah, well, then you're probably going to get subpoenaed as well, and they're going to try to find out what exactly that arrangement was. And that's why if someone says something in an email, sometimes you see people do this. They do really sneaky things, like they'll pay half of the bill and they'll say full and final settlement, and then hope that you cash the check. And then, of course, you haven't noticed that they've said full and final settlement, blah, 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 blah. So it's stuff like that. There's all kinds of sneaky stuff people do. So I would advise anyone who's just generally, it's good advice in commercial dealings of any kind. Never let there be a sort of hanging question, right? If someone says something that you're not comfortable with, that you feel needs to be refuted, refute it there and then. And that's generally a good commercial practice to engage in, because remember, you're creating a record as you go through life, and you want to make sure that that record reflects what you want it to reflect, which is the truth, ideally, assuming you're living a clean and decent life. So yeah, that is exactly, for whatever reason, there were emails that went out from the Ethereum Foundation years ago, which said pursuant to our arrangement. My guess is it was a form email, because it went the whole pre-mine, as I understood it, much of it went to guys who were organizing local Ethereum meetups in various cities and things like that. And there was a lot of jockeying for position for the pre-mine. I never did any of that shit. I just attended the meetups. I was interested in it because of the smart contract angle. I was a lawyer. I was in London. I was doing that kind of stuff. So for some reason, someone was like, "Oh, let's put him on the list," and I was just like, "You know what? Like, in case I think Ethereum probably, on net, I think they probably got away with it. I think the limitation date, or the limitation period for their original ICO, runs something like this month. So if there is going to be any enforcement there, I suspect that it's not going to happen, because it's just not going to happen. I think the SEC let that one slide. But yeah, so they got away with it. Good for them. But there are a whole lot of other ones, I think, where people aren't going to get away with it, and that'll be interesting to see.
All right. Anything else you want to talk about? I don't know if you're familiar. I mean, this has been brought up on several of our shows. We have not yet dug into it. I have not read the whole background. United Housing Foundation versus Forman. If you know the background of this, maybe you can just give us a teaser, and then because Drew Hinkes was supposed to debate this versus Gordon Einstein.
Yeah. So that Forman, I haven't read the case in a while. I read it a while ago. But basically, if my memory is correct, it concerned the purchase of units in a co-op, right? So if you purchase units in a co-op, you also have to buy shares in the co-op. So it's not like buying a house where you're saying, okay, if you're out in the suburbs or out in the woods where you are, right? So you buy a piece of land and you get the deed to the land and you own it free and clear, and that's that. And you don't share it with anybody else. If, however, you buy shares in a co-op, what you're doing is you're buying a unit in the building, but you also have to be a shareholder of the building, which entitles you to, or requires you to do certain things pursuant to whatever the agreement is. I'm not a real estate lawyer. I have done precisely zero co-op work, but basically the purchase of the share in the co-op is a securities sale, right? But it is purely incidental to the fact that you've just bought an apartment, right? Or some property or condo in the building.
Well, you don't actually own it. Like this is why this is why I bought a condo and not a co-op, and why for the last 20 years, anytime people ask me in New York, hey, it's mostly in New York. Like there aren't that many. I don't know how many co-ops there are outside of New York. It's mostly a New York thing, as far as I know.
Yeah.
Like, hey, should I buy a co-op or a condo? And I tell them, don't ever, ever, ever buy a co-op. It's a fucking scam.
Yep. So let's say, excuse me, it's to acquire a co-op city apartment, prospective, oh God, co-op city, cannot be transferred.
But it's a legal scam. Co-ops are legal.
Tenant must offer stock, 2 seconds. Resident is committed to make monthly rental payments in accordance with the size, nature, and location of the apartment. Just reading, I'm reading the same. Securities in the peer review, since respondents are not going to probably dismissed. Right. So when viewed, they must be in the terms of, right. Okay. So right. So on the contrary, these instruments are purchased not for making a profit, but for acquiring low-cost housing. So basically, if you want to get the apartment, you have to purchase the shares in association with, in conjunction with purchasing the apartment. You are not buying the shares as an investment, right? There's no that's not really what is the subject matter of the transaction. It's merely a documentary formality of the real economic substance of the transaction, which is that you're buying an apartment. So Forman has been used by some people to argue that if this is where utility tokens come from, this case. So the concept of utility tokens comes from, as argued by promoters of the concept, rather than as found by any court in the United States. So basically people said, listen, well, in Forman, they said that shares that were useful because you were buying an apartment too, weren't securities. Therefore, if you sell, Marmot coin, and the Marmot coins allow you to go pet a fuzzy marmot once a week, then the Marmot coin's not a security either, because it has some utility. It's used for something, which is not actually what Forman said. Forman said, if we look at the transaction, the Securities Acts regulate investment contracts. And if we look at the transaction here and we look at the economic substance of the transaction, what is actually happening with the sale of an apartment? You're not selling securities, you're selling an apartment. With the sale of a physical good, which is being purchased for immediate consumption, even if there is a component to that transaction which contains something which is in form a security, that is not in substance a security, which is designed to be regulated by the Securities Act. So if you then say, well, all right, let's take this for crypto tokens. What we see with crypto tokens is we see a lot of people doing things that are in form, not securities offerings, fine, but in substance, they are securities offerings. So they're kind of looking at form backwards. Forman had a security in it, but it was not a securities transaction. So then the token sales have securities in them, and they are securities transactions when we run through the common law tests and arrive at the answer. The key thing with Forman is that it wasn't when you ran through the common law tests and you arrived at that answer. It was just a documentary formality.
Yeah, it's and this makes a lot of sense. So I can't wait for Drew to argue this against Gordon or anyone else that wants to get involved, because like again, this is like, if it quacks like a duck or looks like a duck, right? In this case, it is so obvious that the utility is the apartment, and that apartment comes with an element of you also being an owner, of the building, like in a way.
It's not even that the utility is the apartment. The transaction is for an apartment, right? It doesn't matter that the apartment is useful to live in. It doesn't matter that you could operate a kitchen out of the apartment. It doesn't matter that you could operate a nail salon out of the apartment, and that it's somehow useful to you. You're buying an apartment. You're not buying a security. That's the point. So it's not about whether the thing is useful or not. The question is what the transaction is for.
And I'll argue with Jason all day that 99.9% of the people that bought the Veritaseum token never intended to use the goddamn platform.
Who knows? I'm not a Veritaseum purchaser, so I don't know. What I would say is the better option, I think, for those kinds of things is to really fastidiously keep these things out of the United States and ensure that U.S. persons aren't touching them if you insist on doing it to begin with. So, obviously I'm not a big token fan, unless, more of a Bitcoin and an infrastructure for Bitcoin kind of guy. But if you're going to do it, don't do it in the U.S. Is really the answer there.
All right.
So, not legal advice. If you want legal advice, you need an engagement letter.
All right, guys, I kept stalling, trying to wait for Drew or Gordon or someone else to join us, but it looks like our time is up. I'm going to go ahead, as usual, play a 30-second clip of our Moment of Zen. Hopefully, you will be able to hear it, and we'll send you guys off. Oh, and why is there no audio? Oh, come on. It's worked before. Hold on, give me 1 second. I'm gonna mess with it for a second. Oh, that's why. Let me try this. No, let me try this.
How safe are we here?
Oh,
in the
got
US,
it. Perfect.
Questions.
There we go.
Yeah, I had a question. I appreciate you guys making this happen and you being here, Derek. But the question I had, I've been going through ICOs and researching a little bit. And how safe are we here in the US not being an accredited investor investing in this ICO?
How safe as you or for us?
For myself.
You guys are fine. I think one thing I've learned a lot in the industry, especially since working in the finances, as long as the people make money, nobody complains.
You love that, right?
You tried playing that a few weeks ago, and it got I think it got stuck, and so it didn't play. That's a classic. That's a classic, right there. Classic. Well, yeah. Obviously, that's not good legal advice. As long as you make money, nobody complains. Well, I think Reggie Middleton.
And that's coming from a guy who's the CEO of the ICO.
Which ICO was that?
That was Token Pay, one of my favorites.
Favorites as in favorites to complain about, or favorites as in?
Oh, they're the ones they're the ones that sent me a cease and desist letter.
Okay, that's fun.
You can see how that's working out for them. And I did a whole episode about crypto lawyers because it got sent to me from a lawyer. So I looked up the lawyer. His expertise is literally in real estate and estate planning.
Yeah, that's yeah. I've seen clients get random cease and desist from people who are estate planning lawyers. And you're just like, clearly, like, this is the only person that whoever is involved in this. Oh, well, I know Joe Bloggs. He's a lawyer. And they send a random cease and desist, or or a DMCA. Those are always fun.
And
but
doing some research. The cease and desist, I can show it to you. So I did a whole episode about this. It's probably on Twitter as well. So oh man, you didn't see that one. I'll search for it. Tone Vase, T-Pay. I mean, there'll be like 1 million hits, but maybe it'll be the top one.
You're such a big deal, Tone.
Oh yeah. So the CEO of the company also happens to own a website with these 4 letters, and then I had a whole I had a whole expose about that. But I'm looking for I may have to Google it in Google instead of in search. Anyway, so their cease and desist letter
Josh Garza. I haven't seen that name in a while.
Hold on, they were more popular. Let me try Token Pay. I just want to find that There we go. So this was the episode that I did, and maybe.
Well, then I got your cease and desist here. I'm gonna send it to you.
Oh, you found it. You Googled for it. Perfect.
I did.
You did a better job than me. So I did this whole episode about it, but that was somebody else tweeting it out. Where'd you send it to me? There. Okay, cool. I just didn't want to go to my Google. I could have done it somewhere else.
And that letterhead is something else.
Well, here's the thing, right? Let me see what this brings. Do I have it side by side? I do.
Yeah.
So if you look at it side by side, it was basically like direct copy of another letter from obviously a completely different lawyer from like 2007 case. So if you just read them side by side, the whole thing is like has like 95% similarity.
Well, you know, that's the great legal scam, right? Is that we all use templates. So
no, but the
like,
template, but
generally,
no, but you use a template within your own firm. You don't just go randomly find one on the internet.
If you're a hack, you go randomly find one on the internet, and then what you do is when someone then sends it to you. So I received on behalf of a client a DMCA takedown notice, and the DMCA takedown notice was so I Googled a line from it, and it came directly from some web page of being like, oh, gee, I need to send a DMCA takedown notice. How do I do it? And then there was a forum, and there was a page that said, this is how you do it. And of course, it missed a certain things, like, for example, any DMCA takedown notice is made under penalty of perjury. And so it missed the appropriate attestation. And so then I just responded and I was like, listen, thanks for this. I note that you didn't make the statement under penalty of perjury. Could you kindly, I also note that this is fair use. But if you really want to send back this letter and with the appropriate attestation saying it's under penalty of perjury, be my guest. Never heard back from them again.
Right.
So when people rip those things, it's just generally like, it's a good way to understand if you do any diligence at all that they're not serious. So.
Right. That's true. And that's why I had no problem doing an entire crypto scam episode about this lawyer and their law firm and their
Please
letter.
be aware that this letter is copyrighted by our law firm and you are not authorized to republish this.
Right.
What a jerk. That's
Right.
fantastic.
And they copied that paragraph word for word.
That's just not true. That's just scary.
I know.
That's just,
and it isn't true, right? Because basically the reason why this letter, the letter that they copied, basically, the letter that this lawyer copied, the reason why this letter was on the internet, right, is because the person who this letter was sent to, his lawyer, had a public reply showing this letter. And that's how I saw it. And the lawyer that replied to this basically made fun of this statement, saying that is actually impossible to do.
Well, then not only that, the letter that's the second letter, which is claiming copyright, is claiming copyright over the first or the text that was written by the lawyer.
Exactly. And but this letter was probably original, and the lawyer replying to this letter basically said, good luck, you can't actually copyright this letter.
I mean, you can, but it's not like you can, but saying you're not authorized to republish it in any manner is absurd, because it's that they can't do. But like, it's just such a, I don't know. Generally speaking, if you're going to send a demand letter, you want to make sure that it's not embarrassing to yourself.
Yeah.
Let alone your client.
At least he changed the dates.
Yeah, that's always a bonus. That's a bonus. But copy pasting is like, I remember once I was working on a deal and some junior associate was also working on the deal. And for some reason, they needed to change the word public to private, and the word public appeared like 300 times in the document. So they did a global change.
Oh, boy.
And as a result of the global change, after the change, the document referred to the private of France. So, that was the dangers of copying and pasting and not reading documents are you learn that one early.
That's great. And the best part is like the You got to watch that episode. Actually, I think it was my last crypto scam. It was still like a year ago. Is that the court rulings that they referenced in order to accuse me of libel, according to this letter, and I looked into those court cases, and like they were like supporting my case. Basically, one of them basically said that as a blogger, you can't, and you basically opinions aren't libel.
Yeah, I mean, I'm not a New York lawyer, so I'm not going to, question what, what those cases, and I'm certainly not a New York defamation lawyer, so I'm not going to comment on that. But given the end of the letter regarding the little copyright bit, that's just not it's just not a credible threat. So like, it's just, why put it in? It just makes you look silly.
All right, I'm gonna let you go. I'm gonna let our audience go. It's been another great episode. We definitely gotta have an episode solely dedicated to this concept of a utility token, because it's still getting out of control.
I'm out. I'm in for that. I'm down.
All right, cool.
Have a good one.
Thanks for hanging in there, and I'll see you soon.
See you soon.
Later, man. Bye, guys. If you like this content, please check out tonebase.com. You can support through the affiliate page if you're going to use those products or services, and check out other stuff like the upcoming event in Bali. All right, guys. I'll talk to you all on the next one.